Mumbai, Nagpur, Aurangabad, and Panaji. In May 2019, His Lordship was elevated to the Supreme Court of India, where he continues to serve with distinction. Please join me in extending a warm welcome to Honorable Mr. Justice Bhushan Ramakrishna Gavai.
Honorable Justice, Honorable Shri Anmolu, I'm sorry because we always have judges on the podium and therefore Honorable Shri Anmolu Revant Reddy Garu, the Honorable Chief Minister of Telangana, my dear friend from our neighboring Supreme Court, Honorable Justice Nawaz, my dear friend, old friend from my neighboring state, Justice Alok Aradhe, the Chief Justice of High Court for the state of Telangana, and all my esteemed brother and sister judges from the Telangana High Court, Dr. Peter Maynard, the President of Commonwealth Lawyers Association, my senior colleague, Honorable Justice Nageshwar Rao, Shri Sudarshan Reddy, the Learned Advocate General for State of Telangana, Shri Tariq Khan, the Secretary of the Iamc, the man behind this conference, Advocate Santhanam, my colleague from Chennai, Madras High Court, Justice Rajendran, the office bearers of the Bar Council of Telangana, the office bearers of the Bar Association. There are many senior advocates and advocates who have come from Supreme Court of Delhi, the lawyers from Hyderabad, the participants from different states of the country and also the Commonwealth countries, and all my dear friends. At the outset, I thank the organizers, the IAMC and the Commonwealth Lawyers Association for organizing this conference and giving me an opportunity to be with you this evening. As a matter of fact, Honorable Justice Nageshwar Rao had issued a command to me about 6 months back that I should reserve this day for Hyderabad, and around I was to come on 23rd, but 2 months back when Mr. Sanathan met me at Kumarkon in Cochin for a conference, he told me I have to come on 22nd and not 23rd. So I had to rush after finishing the court work. I'm really grateful to the organizers for giving me this opportunity. As I address this August gathering, I'm reminded of the words of Nelson Mandela, who once said, and I quote, "If you want to make peace with your enemy, you have to work with your enemy. Then he becomes your partner," unquote. These words, though simple, encapsulate the ethos underlying meditation and arbitration. MEDA is not merely an idealistic inspiration, it is a pragmatic blueprint for turning adversarial litigation into collaborative problem solving, where parties cease to view each other as opponents and instead work together towards a mutually beneficial resolution. One of the first known cases of MEDA in the international arbitration was the case of IBM versus Fujitsu. This case is considered exceptional in many ways. The stakes and complexities involving intellectual property issues were gigantic. IBM, the world's largest computer company, and Fujitsu, Japan's largest computer manufacturer, were disputing claims involving the proprietary rights to thousands of computer software programs and alleged damages amounting to several $100 million, which arose out of an arbitration clause provided in a settlement argument. Although the arbitration clause did not provide for mediation, but the parties, on the advice of the arbitrators, agreed to try mediation. During the mediation, the parties agreed to a lump sum payment of the license fee by Fujitsu. The outcome proved to be a win-win for both the parties, achieved with the added benefit of avoiding the expenditure of resources that would have been required had the dispute continued for another year or more through arbitration. Thereafter, an award was passed in a period of about 2 years, which was commendable in itself. This case serves as a compelling example of the potential inherent in leveraging and combining innovative dispute resolution techniques such as mediation and arbitration to craft a procedure tailored to the unique needs of a specific conflict. Mediation before arbitration offers two key benefits. It provides parties with the chance to resolve dispute in a timely and cost-efficient method, and provides the flexibility to the parties to settle their differences on their own terms. Mediation acts as a filter, resolving certain aspects of the conflict while leaving fundamental legal issues for arbitration. If the mediation fails or certain issues remain unresolved, the process continues with the arbitration, or if parties settle parts of a dispute, it can be incorporated into final arbitral award. Made-up processes guarantees that the conflict will be resolved in the end of the journey, either through an agreement as a result of mediation or through an arbitration award if no agreement is reached. Mediation fosters dialogue, understanding, and compromise, while arbitration ensures a binding resolution, balancing flexibility with finality. Together, they create a powerful mechanism that not only resolves dispute, but often strengthens the relationship between the parties. Whether applied in international trade disputes or complex commercial disagreements, this approach exemplifies the potential to move from confrontation to collaboration, reflecting Mandela's timeless wisdom in practice. It highlights the critical shift in perspective that both mediation and arbitration require to move away from adversarial positions and towards a process that fosters collaboration, interest-based processes, and ultimately a peaceful resolution. The theme of the conference, Bridging Divides, Innovative Approaches to Conflict Resolution, is particularly timely. Bridging divides is a necessity in an era that increasingly calls for inclusive, efficient, and equitable solutions. In Made-up, we find an approach that exemplifies this spirit. We live in a world marked by complexity and interconnectedness. The judiciary is tasked with resolving challenges ranging from international trade disputes amounting to crores of rupees to conflict among two small businessmen amounting to a few lakhs of rupees. These disputes often demand solutions that are as innovative as the challenges themselves. In this context, traditional litigation, while indispensable in certain cases, has its limitations. The adversarial nature of courtroom battles often exacerbates divides rather than mending them. The cost, time, and emotional toll involved can make justice feel distant. This is where the Made-up, an elegant blend of mediation and arbitration, emerge as a powerful tool. By combining the flexibility of mediation with the finality of arbitration, it offers a dynamic framework capable of adapting to the unique needs of each dispute. Section 30 of the Arbitration and Conciliation Act 1996 states that the arbitral tribunal may, on the agreement of the parties, encourage the settlement of the dispute through mediation, conciliation, or other processes at any time during the arbitral proceedings. If the dispute is settled, the arbitral tribunal may, on the parties' request, record the settlement in the form of an arbitral award on agreed terms and terminate the arbitration proceedings. Since I have taken over as the executive chairman of NALSA, Recently, I updated myself with the latest statistics on cases resolved through mediation, which reveals that mediation is already a success story, and with the huge potential that it has, it will be a matter of time that it is widely adopted. Statistics demonstrate that 1,47,513 cases were successfully resolved through mediation between April 2023 and March 2024. An increase of 2,000 cases compared to the period between April 2021 and March 2022. This steady growth underscores the growing acceptance of mediation in India. Recognizing this shift, the Government of India as well as judiciary have also taken significant steps to institutionalize and promote mediation. The Government of India passed the Mediation Bill 2021 in August 2023, marking a pivotal moment in the evolution of alternate dispute resolution in India. With the presidential assent in September 2023, the Mediation Act 2023 became the nation's first standalone legislation on mediation. More than 1,000 cases were resolved through special Lok Adalats set up by the Supreme Court. This demonstrates how ADR can provide efficient, cost-effective, and amicable solutions, reducing the burden on courts and ensuring faster access to justice for citizens. The Government of India has been actively addressing the practical challenges associated with arbitration and has undertaken significant amendments to enhance its effectiveness as a mode of dispute resolution. Key amendments were introduced to the Arbitration and Conciliation Act in 2015 and 2019, reflecting a concerted effort to refine the arbitrational framework. Government has also taken various steps, has set up experts committees, and has been promoting the cause of ADR and not just arbitration in India. A significant milestone in India's arbitration journey is setting up of a specialized arbitration bar called Arbitration Bar of India, which I have learned is taking various initiatives to inculcate best international practices in Indian practice of arbitration. The Indian judiciary has also played a pivotal role in supporting arbitration. Many of the amendments over the years have drawn inspiration from judicial pronouncements and discussions. In several landmark judgments, courts have reinforced the sanctity of arbitration agreements and reaffirmed the finality of arbitral awards. Additionally, courts have adopted a stricter approach towards injuncting arbitral proceedings, ensuring such interventions are not granted routinely. This judicial stance has provided greater certainty and stability to the arbitration process, bolstering parties' confidence in its reliability as a dispute resolution mechanism. These proactive measures by both the government and the judiciary have significantly contributed to promoting mediation and arbitration in India. And I am hopeful that with the collective efforts of legal professionals, the judiciary and the government, MEDAP can also emerge as a preferred dispute resolution mechanism, combining the best of both mediation and arbitration to deliver efficient, fair, and amicable outcomes. Bridging divides also requires us to bridge the gap between tradition and innovation. We must embrace the transformative potential of technology, artificial intelligence, and cross-disciplinary approaches to reimagine justice delivery systems. By integrating these advancements, we can create mechanisms that are not only efficient, but also more accessible and adaptable to the diverse needs of the society. One of the significant innovations in dispute resolution is the rise of online dispute resolution. ODR extends the principles of traditional dispute resolution, such as mediation, arbitration, and negotiation, into the digital realm. Other technological advancements are the adoption of hybrid hearings and the real-time transcription services. By seamlessly blending traditional principles of mediation and arbitration with cutting-edge technology, we can create processes that are adaptive, transparent, and inclusive. This synergy ensures that MEDAP evolves into a truly modern contemporary dispute while addressing the complexities of contemporary disputes while upholding the values of fairness and equity. To bridge divides, it is essential to not only embrace innovative processes like MEDA, but also to ensure that all stakeholders, lawyers, mediators, arbitrators, and the general public are fully aware of its benefits and prepared to engage with it effectively. Lawyers must understand the strategic advantages MEDA offers their client, while the general public must be made aware of the accessibility and ability to provide timely resolutions. At the same time, it is imperative that mediators and arbitrators have specialized trainings to be able to handle the complexities. Effective MEDA practitioners must navigate the delicate balance between facilitating cooperation in mediation and making impartial determinations in arbitration. This demands a mastery of conflict management and procedural fairness. Many institutions are providing trainings, including online mediation training web portal launched by the Supreme Court on 18th of September 2024. I was informed by Mr. Tariq Khan, the Secretary of Iamc, that he also had played a major role in preparing the web portal. By prioritizing education, training and outreach, we can bridge the divide between potential and practice, ensuring that MEDA becomes a trusted and effective tool for resolving disputes. As per experts, MEDA is a common form of dispute resolution in Asia, aligning with a broader preference among parties in the region to be more litigation averse. MEDA is essentially contemplated in the arbitration legislations of Hong Kong, Japan and Singapore, in addition to the procedural rules of some of the arbitration and mediation centers in those jurisdictions. The experiences of these jurisdictions offer valuable insights into the successful implementation of MEDA frameworks. These examples highlight how clear legislative provisions and well-defined procedural rules can facilitate the seamless integration of mediation and arbitration. As MEDA continues to gain traction globally, there is an opportunity to reflect on these practices and explore how similar innovations might enrich the dispute resolution landscape in India. My colleague from Sri Lanka Supreme Court is present here. The representatives of many Commonwealth countries are here. I think we can carry this message and we can carry this movement on a global level, and at least we can have a cooperation of all the Commonwealth countries so that we can all work together. We, that is the government, judiciary and lawyers, are the architects of a world where disputes are not walls but bridges, where divides are not permanent but pathways to deeper understanding. The way we engage with conflict sets a tone for others, especially for the parties who come before us. MEDA offers us an opportunity to model a different kind of dispute resolution, a process where collaboration takes precedence over winning and losing. Abraham Lincoln, about the role of a lawyer, said, and I quote, "Discourage litigation, persuade your neighbors to compromise wherever you can. Point out to them how the nominal winner is often a real loser in fees, expenses, and waste of time. As a peacemaker, the lawyer has a superior opportunity of being a good man," unquote. So the contribution of all of us is emphasized by these words of Abraham Lincoln. As we embark on these 3 days of deliberations, let this conference serve as a forum for bold ideas, meaningful dialogue, and actionable strategies. The collective expertise of all of you, built on years of experience in the courtroom, mediation, and arbitration hearings, will be the foundation upon which new solutions can be crafted. I look forward to the discussions and collaborations which started today afternoon and will go on for next 2 days. And I'm sure that these discussions and collaborations will unfold many nuances in the field of mediation and arbitration. Since this is an inaugural function, I would like to stop at this. You have been attending working sessions from afternoon and also have to undergo the sessions for next 2 days. And in any case, we are today talking about the bridge divides, and therefore I would not like to create a divide between the inaugural session and the dinner for which all of you are eagerly awaiting. I once again congratulate the International Arbitration and Mediation Council, Aurangabad, Hyderabad, and the Commonwealth Lawyers Association for organizing this conference on such an important issue at such an important point of time. Thank you very much. Kala dhanyavadalu, kala dhanyavadalu.
Thank you, Your Lordship, for addressing us with your profound words of wisdom and eloquently outlining the blend of mediation arbitration model as a unique and much needed dispute resolution mechanism. May I kindly request all the dignitaries to please step forward for a picture. May I request the organizers and Mr. Santan sir to kindly join the picture as well. So we have a request from the Iamc team as well to quickly join. And now to conclude the day on a ceremonious note, we will now proceed for dinner hosted by the Chief Minister for the state of Telangana. I request all the participants to please proceed to the back of the hall where the dinner is being served. Request you to please proceed to the back of the hall where the dinner is being served.